Hi guys! Welcome to another episode of Atty. Vlogger, Law for the Everyday Layman. Today we take up part 12 on the law of sales and we'll talk about the extinguishment of a contract of sale as well as conventional redemption. Now if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? Now, let's begin with the extinguishment of a contract of sale. Remember that a contract of sale is a special contract and as such is subject to the general rules on obligations and contracts. Okay? As a consequence, a contract of sale is extinguished by the same modes of extinguishment of obligations. Okay? Namely, payment or performance, loss of the thing due, confusion or merger, condonation, compensation, novation. We also have rescission, annulment, fulfillment of a resolutory condition, and we have the special rules of extinguishing a contract of sale. Okay? Now, those special rules are scattered all throughout the provisions on the law of sales. And they mostly come under the topic of rescission, okay, such as in 1484 or the recto law or the action redhibitoria in case of breach of warranties against hidden defects, no? And also rescission in case of sales of real property for lump sum or sale of real property with a certain area with the price per unit of measure. And we also have rights of resale, rescission, etc. Okay, so those are some of the special rules in sales, and we've taken these up in our in the previous videos. Okay, but there are two special modes of extinguishing a contract of sale, which are conventional redemption and legal redemption. Today we'll take up conventional redemption. So what is conventional redemption? It is simply a right which the seller reserves to himself to reacquire the property which he has sold, okay? Provided he pays the price, the expenses of the contract, the other legitimate payments that may have been made, and the necessary and useful expenses which may have been made upon the thing, if any, okay? So, when we talk about conventional redemption, we only talk about two major topics. No, we have the conventional redemption, or the retro sale, or the sale with the right of repurchase. No, it is a true sale with right to repurchase. If it's not a true sale, then that's the other topic. No, it is an equitable mortgage. We'll talk about equitable mortgage later on in the video. Okay, for now, let's talk about the true sale with right of repurchase under conventional redemption. Okay, so the essence of a sale with right to repurchase is that title or ownership over the property is immediately vested in the buyer a retro. We call him buyer a retro because they are, and we call the seller a retro because they are under a pacto de retro, meaning a sale with right to repurchase. Okay, this is to differentiate them from the mere buyer who has no obligation to return the thing upon repurchase by the seller. Okay, so again, the essence of conventional redemption is that the title or ownership is immediately vested upon the buyer a retro, subject only to the resolutory condition of repurchase by the seller a retro. Okay? Now, why is it a resolutory condition? Because upon repurchase or exercise of the right to repurchase, then the right to the property of the buyer is now lost or extinguished. Okay? And the buyer will now have to return the property and the seller will have to return the price. As a consequence of the rule I mentioned earlier that the title and ownership is immediately vested on the buyer, the effect of this is that the buyer, a retro, is now subrogated to all the rights and actions of the seller. Why? Because the ownership na nga is immediately vested. Okay? And second, the buyer a retro is already entitled to immediate possession of the property, except of course if there is a stipulation to the contrary. The buyer retro is also entitled to receive the property free from other charges or encumbrances or burdens, but the buyer retro must respect any lease that may have been made by the seller prior to the sale. Okay, he must respect the leases if there are any. Okay, now this conventional redemption or right to repurchase is a purely contractual right, meaning that it should be reserved at perfection in the same contract as the contract of sale. It should not be in a separate contract, okay? And it should be reserved at perfection. And the consideration of a right of repurchase, it does not need a separate consideration because the consideration is the same consideration as the contract of sale, okay? This right of repurchase is also a real right, meaning it can be enforced against third persons, so much so that the law says that the seller, a retro, can bring any action against any possessor who derives the right from the buyer, a retro. Okay? However, that right to bring actions against possessors will not apply to a subsequent buyer in good faith and for value, no? If the right of repurchase is not annotated or registered. Okay? So registration is still necessary to bind third persons. Okay? Now, this right of repurchase is also potestative. Why? Because it depends solely on the will of the seller a retro, whether or not he will decide to exercise the right of repurchase. Okay? This is also a resolutory condition. I discussed this earlier. Okay? And again, it must be reserved at perfection. Now, let's talk about an important topic, no? The period of the right to redeem, no? Now, the parties may put a stipulation in the contract as to the period, or they may even choose not to. And in case there is no stipulation as to the period of redemption, then the law says that the right to redeem will last for 4 years from the date of the contract. Okay, so you can only redeem within 4 years if you did not agree upon a period to redeem. Okay, but in case there is a stipulation that is clear as to the period, or even if there is a stipulation that is not clear as to the period, but it is clear that a period is intended. Okay? Again, if there is a stipulation and the period is clear, or there is a stipulation but the period is not clear or it is indefinite, then the period cannot exceed 10 years from the date of the contract. Okay? In other words, the right to redeem will only exist for 10 years. In other words, any excess over the 10-year period will be void. So if the parties say you can exercise the right to redeem within 12 years, then the right to redeem will only be valid for 10 years and the excess of 2 years will be void. Okay? What's the purpose of the law in limiting the redemption period to 10 years, no? This is for public interest, okay? Because having a period of redemption for more than 10 years renders the tenure of the property uncertain, okay? And it redounds to the detriment of the property because the holder is not inclined to preserve or cultivate or improve the property because he knows, no, that his enjoyment of that property is only temporary. It can be lost at the moment that it is repurchased by the seller a retro. Okay? So I'll give you some examples, no, to help clear this up. If the stipulation says at any time, then there is a stipulation as to period because a period has been intended. So the period now cannot exceed 10 years. Okay? The right to redeem can be exercised only within 10 years. What if the stipulation says, as soon as I put up a business? Then that is not a period, that's a condition, okay? And since it's a condition, there is no period, there is no stipulation as to period, and therefore, the period is only 4 years, okay? This is according to the case of Medel versus Francisco. Now, what if the stipulation is negative? you cannot exercise the right within 3 years, then that is a condition, okay? There is no period stipulated. So, the period is 4 years counted from the date of the contract. So, in other words, the seller has a total period of 7 years. It's just that in the first 3 years, the seller cannot exercise the right to redeem the property. Now, that kind of stipulation is valid, okay? As long as it does not exceed 10 years. So, in other words, if the stipulation says the right of repurchase cannot be exercised within 8 years, okay? That is still valid, but the seller retro only has the balance of 10 years or 2 years, no? Within which to exercise the right of redemption. Okay? This is according to the case of Rosales versus Reyes. Finally, what if what is stated is that the right to repurchase can be exercised at any time after 10 years? Okay? That stipulation is now void. Because remember, the law says that if there is a period, it cannot exceed 10 years. And here, the right given to repurchase can only be exercised after 10 years. So that stipulation is void. Okay? So, seller retro who tries to repurchase the property on the 12th year, okay, will not be allowed to repurchase. Okay? Because the stipulation is void. This is according to the case of Baluyot versus Venegas. Okay? So the rule is that the right to redeem the property must be exercised within the redemption period. And failure to pay the price, that does not affect the period to redeem. It will keep on running. Okay? And if the redemption period expires, then the title and ownership over the property is now consolidated. Okay? Consolidated in the buyer retro by operation of law. And just take note na in case it is a real property, even though the title is consolidated by ownership of law, the consolidation of ownership will not be recorded in the registry of property until a judicial decree or order is issued after giving the seller a retro an opportunity to be heard in the case that is brought to determine the true nature of the contract of sale. In other words, there is a case to determine if it's a true contract of sale with right of repurchase or if it is a unequitable mortgage. Okay? So, again, you have to exercise the right to repurchase within the redemption period. Okay? Now, what if the property or thing produces fruits? Okay? There are certain rules. Okay? First, no? What if fruits exist at the time of the sale and the buyer retro paid for these fruits? Then, of course, at the time of redemption, if the property is repurchased, the buyer retro must be reimbursed for what he has paid. Okay? Second rule, what if the fruits exist at the time of the sale, but the buyer retro did not pay for them? Okay? Then, at redemption, at repurchase of the property, the buyer retro will not be reimbursed for the fruits that exist at the time of the sale. Okay? And finally, what if there are no fruits, okay, at the time of the sale, but when the property is redeemed, fruits exist? What's the rule? Okay? The rule in this case is we have to apportion the fruits proportionately between the seller retro and the buyer retro. And what does the buyer retro get? He gets a share of the fruits in proportion to the time which he has possessed the property in the last year, counted from the anniversary of the date of sale. Okay? And the purpose of this, no, is to compensate the buyer retro for his expenses in cultivating or gathering the fruits. Okay? Now, how is the right of redemption exercised? Okay? Mere tender, as a general rule, is sufficient to compel redemption. Okay? As long as the tender is given genuinely with an intention to pay. Okay? Then it is sufficient to compel redemption. However, tender alone without paying the full price, okay, does not relieve the seller retro from his obligation to actually pay for the price, other legitimate payments, useful and necessary expenses, and the expenses of the contract. Okay? So, tender alone will be sufficient to get it started, but it is not enough to extinguish the obligation. Okay? So, the seller has to pay those things I mentioned in order for him to successfully repurchase the property. Okay? Now, consignation is not necessary. Consignation can only be necessary in the following three cases, no? In case the buyer cannot be found, so you consign the payment with the court, no? Second case, if the buyer wrongfully refuses to accept payment. And finally, consignation is proper in case the seller has initiated or filed a case to enforce the contract of sale. Okay? Now, there is a certain rule, no, that will allow a seller a retro to repurchase the property even if the redemption period has expired. Okay? So what is this rule, no? This rule requires that a case must have been previously filed, and that case must have been for the purpose of questioning the nature of the contract. Okay? In other words, the issue there is whether or not this is a true contract of sale or is it an equitable mortgage or other contract. Okay? If that case has been previously filed, then the seller a retro will have 30 days from final judgment to repurchase the property in case the decision was that the contract is actually a true sale with right to repurchase. Okay? Now let's go to some special rules in case of multiple parties. And these are contained in Articles 1611 to 1615 of the Civil Code. And the purpose of these articles is to discourage co-ownership. Okay, the law as much as possible discourages co-ownership and favors a partition. Why? Because the co-ownership is a situation where a single co-owner or two co-owners may be subject to the desires of the majority. Okay? And it results in a conflict of management. Okay? So, the law would, as much as possible, in order to promote the improvement, cultivation of the property, the law would want to partition the property so that each can cultivate and improve the property to the best of his abilities. Okay? So, as a consequence of that policy of the law, no, which discourages co-ownership, a co-owner may therefore at any time demand partition with respect to his share. Okay? He can ask that the property be divided and he be allotted his share. And there are certain rules when it comes to this, no? If the property is essentially indivisible, then the whole property may be allotted or given to one of the co-owners, subject to that co-owner's obligation to now indemnify the others for their share. Okay? But if the co-owners cannot agree on the person to whom the property will be adjudicated or given to or allotted to, then the property shall now be sold, and then the proceeds of such sale will now be distributed among the co-owners. This is now where 1611 comes in. So now let's say there is a buyer who is able to purchase a share of the one of the co-owners to the property. Okay? The buyer buys it, and the contract of sale is a sale with a right of repurchase. Okay? Now, the buyer becomes substituted and is now a co-owner with the other co-owners over that property. Because remember, he only bought a share. Okay? Now, in case that buyer is able to acquire the whole property, let's say because he demanded partition, no? And he was the one who was able to acquire the whole property, then in case the person who sold the share initially to the buyer, okay, wants to redeem the property, then the buyer a retro can compel that redeeming co-owner to repurchase the whole of the property. Okay, and this is in accord with the policy of the law, which does not favor co-ownership. In that case, the first co-owner who sold his share can now be compelled to purchase the whole property if he wants to exercise his right to redeem. Okay? So let's make it into an example form. Let's say A buys the share of X, who is a co-owner with Y and Z. No? X, Y, and Z are co-owners of this mass. So A buys the share of X and demands now partition from Y and Z. Okay? A is able to acquire the whole, and here now comes X, who wants to exercise his right of redemption. A now can ask X to redeem the whole property. Okay? So that's 1611. Let's go now to 1612. And the first rule under 1612 is that in case there are several co-owners of an undivided immovable who sell that immovable jointly in a single contract or the same contract, okay, take note, it's the same or single contract, and that contract contains a right of repurchase. If they want to exercise that right of repurchase, they can only do so with respect to their respective shares. So in other words, if X, Y, and Z are co-owners and in the same contract they sell their shares to A, if X wants to redeem the property from A, he can only do so for his share or 1/3, no? Presuming it's equal, no? 1/3. Okay? Second rule, in case there are co-heirs, okay, co-heirs of seller a retro, no? In other words, there is a seller a retro who has sold property to a buyer a retro, and the seller a retro dies and leaves heirs who are now, since plural, no? Let's say there are 3 people, okay? The co-heirs of the seller a retro of an undivided immovable or real property can redeem only their respective portions which they have inherited. Okay? So in other words, let's say A sells property to B, then A dies. A leaves behind X, Y, and Z. Okay? Now, X can only redeem his share, presuming it's equal, he can only redeem 1/3, Y can only redeem 1/3, and Z can only redeem 1/3. Okay? Which now brings us to Article 1613. Okay, and under this article, the buyer a retro can refuse partial redemption and may require that all the sellers a retro or all the co-heirs redeem the whole or come to an agreement as to who will get the whole property. Because remember, co-ownership is not favored, and as much as possible, the property should be whole or entire. Okay? Now, when it comes to 1614, if there are co-owners of an undivided immovable who sold their share individually, remember in 1612, the sale was jointly in the same contract. But now, under 1614, the co-owners have now sold their respective shares in separate agreements, like separate dates, separate instruments, okay, so separate transactions. Now, in this case, each of them can independently exercise their own right of redemption for their own shares, okay? And the buyer a retro cannot compel any of them to redeem the whole, okay? So that's the difference between 1614 and 1612. In 1612, there is an instance when taken in relation to 1611 that the buyer may compel the redemption of the whole property, but in 1614 you cannot compel one of the redeeming co-owners to reacquire the whole because they have executed separate contracts or separate agreements. Okay? Now, when it comes to Article 1615, the first rule is that the buyer a retro has left several heirs. Okay, he has died. In such a case, the action for redemption meaning the action to exercise or enforce the right of redemption, can only be brought against each of the buyer retro's heirs, no? Okay, for the respective share that they inherit. Okay, so in other words, if A sells a property to B, okay, and this time around B dies, no? In the example earlier, it was A who died, okay? But now it is B who dies, and he leaves X, Y, and Z as his heirs. Let's say A wants to redeem the property now. If B were alive, A could redeem the whole property. But in this case, B died and transmitted his property, which is now divided equally amongst X, Y, and Z. Okay? So if A wants to redeem the property, he can only bring his action for redemption against X, against Y, then against Z for their respective shares. However, the second rule in Article 1615 states that if the inheritance is divided or partitioned, okay, then the thing is awarded to one of the heirs, then redemption may be brought against that heir for the whole of the property. So in that same case, instead of the property being divided in amongst the three heirs of X, Y, and Z, no, the property is instead the estate of B is instead partitioned, and the whole of the property which A sold previously is now just given to X alone. Then that is the case when A can go against X to redeem the whole property. Okay, so that's it for the special rules, and that's it for conventional redemption in case of a sale, of a true sale with right of repurchase. Okay, so now we can go to equitable mortgage. Now this is a very important topic. And what is an equitable mortgage? Okay, an equitable mortgage is one which lacks the proper formalities of a mortgage. Okay, but it shows the intention of the parties to make the property as a security for the payment of a debt or fulfillment of an obligation. Okay, if you want to learn more about mortgage, I have a video on real estate mortgage and chattel mortgage. Please just watch those two, no? So you can understand mortgages better. But in this case, instead of an equitable mortgage exists when the parties made it to appear that it is a sale with right of repurchase, but it is actually an equitable mortgage because the real intention of the parties was not to transfer ownership but to make the property serve as security for payment of a debt or fulfillment of some other obligation. Okay? Now, the law makes it easy for us by giving us presumptions when we can presume that the contract of sale is actually an equitable mortgage, no? First, if the price is unusually inadequate, no? Like let's say, let's make it an extreme example. 1 peso for 15-hectare land, no? That's unusually inadequate, no? Second is when the seller remains in possession of the property. Okay? Third, if there is an extension of the redemption period after it has expired. Okay? Next, when the buyer retains part of the purchase price. Okay? Another presumption is when the seller binds himself to pay the taxes. Okay? Because as a general rule, it is only the owner of the property who should pay taxes over the thing. Okay? And finally, any other case where the parties intended the transaction to secure the performance or payment of a debt or fulfillment of an obligation. To this list of presumptions, the law adds another, okay? That in case there is a doubt, okay, you are unsure whether the contract is one of sale or if it is equitable mortgage, then you presume it to be an equitable mortgage. Okay? Now, the purpose of this law on equitable mortgage is to curtail the circumvention of the laws against usury and the law against pactum commissorium. I discussed pactum commissorium in my videos on mortgage, but just to be clear, pactum commissorium is prohibited by law because this is a situation where the mortgagee or the person to whom the thing is mortgaged to secure payment of the debt, or the creditor, okay, it becomes the automatic owner of the thing mortgaged in case of the debtor's failure to pay or fulfill the obligation. Okay? So that is not allowed. What the law requires is that the thing be sold at a public auction, and in case the creditor is the highest bidder, then that's the only way he can become the owner of the thing. Okay? So in case the contract of sale with right of repurchase, no, or even an absolute sale, because the provisions on equitable mortgage also apply if the contract turns out to be an absolute sale, no? So in case the contract of sale it turns out to be an equitable mortgage, what is the remedy of the parties? The remedy is to seek a reformation. Okay, I have a whole video on reformation under obligations and contracts. Please just watch that for more, no? For more information. But reformation is a remedy in equity by virtue of which the written instrument will now be made to conform to the true intent of the parties. Okay? In other words, there has been a meeting of the minds. There is a perfected contract. It's just that the written instrument fails to express the real intent of the parties. And this applies in the case of equitable mortgage because on its face, the contract calls it a sale with the right of repurchase or pacto de retrosale, but in reality, the parties intended an equitable mortgage. So reformation is appropriate. Okay? And finally, in case the contract is found to be an equitable mortgage, the remedy of the buyer is not to consolidate ownership. Okay, why? Kasi it's prohibited by law nga. Okay? It's a pactum commissorium, so he cannot consolidate ownership. His remedy now, since the arrangement was decreed to be an equitable mortgage, his remedy is simply to foreclose the mortgage and sell the thing at public auction. If he so desires, he can be the highest bidder and acquire the property. Okay? So that's it for conventional redemption. I hope you may have picked up a thing or two, and please wait for my next video on legal redemption. I hope to see you soon. Bye!